How's everyone doing? Welcome back. Welcome back. Everyone having a good day so far?
Yep.
Yeah?
Yeah.
Not that what?
Conference was okay. All done today.
Which conference was that?
Contracts too.
Contracts. Okay, very good. Let's see. All right. Anything on your mind? Anything from you or lingering? What's that? When's that due? Ah, okay. And then you have to do the arguments after that? Good luck. Good luck. It's actually a lot of fun. I think you'll be stressing it, but I think you'll actually happen. Although you're gonna get some judge can't do it this year. I can't do it. That I find it there's a mix of judges. So it can be some professors, some you may know, some you don't. Usually I try to recuse from my own students, but I don't always have that. They'll have a lot of practitioners coming from outside, and they'll have varying. Okay, what do I mean by that? Some of them will be, a couple years out of law school, and they may remember what it's like to be a afraid 1L who doesn't really know what they're doing, right? Will be 30 or 40 years of absolutely no recollection of what law school's like, and go really hard. Others may have is do not count on the people judging to have read the fact pattern. Don't count on that. Also, not having read it closely. So you need to be very careful to the facts, but make sure you get the facts right, because if you don't, that's your big mistake. It's a lot easier to make a bad argument than to misstate the facts. Once you misstate the facts, you're done. So have the facts cold and be able to explain it. And here's a tell, right? One of the judges may say, counselor, explain to me the facts in this case, right? If they say that they haven't read the, not you, I'm serious, and they want you to walk them through the facts. So take very close care to present the facts in an objective manner. I know you have this urge to shade the facts as the way most favorable to your client and your side. That's not the opportunity to do it. Do that when you're giving your argument. Give the facts straight up. Also, again, don't expect the judges to be familiar with the legal precedents either. I know it sounds really bad, but they probably haven't even read the the whole packet. They probably haven't read it either. If you actually know how this works, a few minutes to judge, we all meet in Dean Treese's office, and he has sandwiches and stuff, right? Then almost around the table. I'm not exaggerating. So use that to your advantage, however you see fit. But make sure you at least have the facts cold and you can present them. Beyond that, don't interrupt the judge. I know that's really super obvious, but you'd be surprised when crosstalk starts, it gets very easy to jump in. So always pause and make sure that you're not talking over the judge. Try to be respectful. Yes, sir. Yes, ma'am. Whatever it is. This is Texas after all. What else? I think they tell you about the dress up and make sure you wear whatever the standard attire is. In no way reference the brief you wrote because they have not even seen it. As the judges, we don't even see the briefs you write. So it doesn't even, don't reference your brief. I mean, you can, but that won't help you. If there are any specific citations to the record that are important, have those at your command, right, at the podium with you. So it's like page 15 of the record, right? Be able to cite that pretty quickly, because especially the judge has the facts, they'll flip to page 15 and say, oh yeah, look, there's a fact. And that will give you a significant advantage of your colleague who's just saying things that aren't in the paper in front of them. So the way it usually works is both sides go, and then they ask you to leave the room for a few minutes, which is always kind of awkward. It's like scram, right? And then they invite you to come back in, and they'll give you some feedback. Again, if there's a professor on the panel, they'll usually make the feedback, in a gentle way. But in the event that it's practitioners, they may not be quite as gentle. So don't be fragile. Whatever they say thank you. Thank you very much. I appreciate your comments, and don't do anything. At that point, you've already been scored, right? But just take it well. They usually instruct us not to be too tough on you, especially because it's your first time doing these kind of arguments. But you always might have a, a tough lawyer who's like, wow, when I went to South Texas, 1964, they weren't nice. And I'm serious. The guy sitting next to me when I judged this last time, I think he graduated South Texas in like the 1960s. So he's been around for a while, and he has a very different recollection of what law school is like. Whether, in fact, that was true or not, doesn't matter. Recollections, fade over time. But just you have to be ready to take whatever Dean Treese throws at you, and it's going to be an eclectic band of judges. Any questions about that? And I usually try to judge every year, but this year I'm not even around, and I can't even do it. It's annoying. All right, any questions on that? Yeah. Usually 3 judges. It might be 4 if they have a glut, because sometimes Treese overbooks, in which case it's 4, but it's almost always going to be 3.
Is this standard is actually Professor Lumbo hadn't said anything about presenting from it.
Yeah.
So this is like the first thing.
We're talking about it next week.
Oh.
Yeah, I mean, I'm pretty sure at some point you're going to come up against this type of. Is that Ashley? Is that right? Okay. Well, in the event that you want to do this, then you'll have to be ready for it. Your class may not be the one doing it, but you get a nice mix of people coming in case your professor actually brings in outside judges, right? So it's literally whoever, as I said, Dean Treese runs the abstract, whoever can basically scramble in, right? Anyway, okay. Anything else? You should all try out for the advocacy board when you get a shot for it. You should really take that seriously. It's a good opportunity. It's not easy. It's a lot of work, but you'll see that we actually have South Texas students winning, national championships every year. In the last week we won like 3 national championships. Like when I go to other schools, people actually know, like, oh wow. Someone said, what they say, like someone said like you're the Chicago Bulls of like it's the old Chicago Bulls of like moot court because you win everything. Okay, something like that. All right, so we got property law. All right, so we got property law. Okay, so we are finishing up our topic on marital property today, and I guess we saved the best for last. Because it's probably the most salient to what many of you will one day focus on if you do family law. So the first 2 classes we spoke about the common law system, which is effectively the property system of about 40-something states. The overall majority of states has common law. And with a common law marital system, even though 2 people are married, they can hold property separate, right? Husband has a job, wife has a job. They each have separate salaries. They deposit their payroll into separate bank accounts. That's separate money. Husband has his property titled in his name. Wife has her property titled in her name. And it's separate. Right? So generally speaking, in these common law states, everything can be separate even though they are married. One of the exceptions to that is if we have something called a tenancy by the entirety, which we discussed in a couple classes before, right? If they take it by the same title, by the same time, with the same instrument, they have joint possession, and they're married, they can actually have a special estate called a tenancy by the entirety. And one of the interesting aspects of this estate is that one party can't unilaterally transfer it. So that's an instance where even if you're in a common law property state, you can actually have it almost like community property, where you jointly own it, and both parties need to consent to a transfer. A couple of you asked me a couple weeks ago, why do we even have tenancy by the entirety? Well, one of the reasons why we have it in the common law states is kind of approximate the type of bond that can be formed in a community property states. It's one of those weird exceptions. Okay. We also discussed with the common law state the elective share, which is a fairly important thing, right? What the elective share says is if the husband writes the wife out of the will, he just disinherits her, gives it all to his kids, the wife can actually say, you know what? I don't want that. I want half. Or if they're kids, I want a third of everything that's marital property. So the spouse, the widow, has the capacity to do that in the event that the other spouse disinherits her or him. Okay? So the issue there is basically even if you're married and you have separate property, whatever is marital property, whatever is shared, basically between a half and a third will go to the widow regardless of what you want. So you can't disinherit your spouses. We also discussed this idea of what is marital property. And then we had a couple cases involving a business degree or a law degree or a career as an opera singer, right? And for the most part, the courts say these kinds of things are not marital property because they're based on the individual effort. Although that one case from New York with the opera singer, that's something of an outlier. I don't know any other court that treats a successful career as marital property that can be divided up. All right, any questions on that with common law marital property? Any questions on that? So today we're going to discuss community property. The rules are quite different from common law. And this is one of those places where it's warned people on the exam. I will be very clear. You are in a state or a community state. Clear. And I can promise community state will be Texas. Make it nice and fun. But you need to be careful about what jurisdiction I'm asking you about. All right? Because the rules are quite different. Also, pay very close attention if the couples move from, say, New York to Texas, or Texas to New York, you know, either way. You have to be very cognizant of that because that's one way it can trip you up very easily. All right. So much like with common law property, while the husband and wife are married, or husband and husband, or wife and wife, I'll just use husband and wife so I don't have to keep repeating myself. While two people are married, the system of property doesn't really make much of a difference, right? Either in Texas or New York, there's no obligation for the husband to give his wife any money. There isn't. There's no obligation for the wife to take care of the husband, right? If the wife says, yeah, I don't want to cook dinner, or the husband says, no, I don't want to pay for this, or the husband says, no, I don't want to mow the lawn, or whatever it is, right? There's really no legal remedy. You can't go to court and seek an injunction to have someone mow the lawn, right? you can't do that. A husband can't go to court and seek an injunction asking his wife to pay for, you know, a new car or something, right? You can't do that. So during the marriage, the property almost doesn't matter. Courts will not intervene. The laws only matter at the time of death or divorce. The only time all these laws really matter is at death or divorce. If you notice, virtually every case we've done involves someone either dying or getting divorced. Okay? So practically speaking, it makes no difference. But theoretically speaking, it does. So in a common law state like New York, husband and wife can have separate property. The husband can have his bank account. The wife can have her bank account. They each have their paychecks deposited there. They never touch it. There's no commingling going on, right? And in the event of a divorce, the husband can keep his bank account and the wife can keep hers. Those separate bank accounts are not marital property. Okay? It's the exact opposite, though, in a community property state like Texas or California. Okay? It's presumed that any property obtained, whether it's money or land, during the marriage is shared. Right? It's presumed that anything the husband or wife achieves is based on the collective strength of this marital bond, this sacred union, right? And without this loving compassion, they could have never had that job, or they could have never acquired that property. It's considered a whole. So any wages earned by one spouse is presumed shared 50-50. Any property earned by another spouse is presumed to be owned 50-50. It's all presumed to be community property. Okay. Now, if the parties agree in a contract, and it generally has to be in writing, that this property will be treated separately, both husband and wife agree, then you can contract around the community property laws. You can do that. But generally speaking, most spouses are not willing to do that. Why would they give up half of all that's being acquired? So those contracts are going to be fairly rare, right? So generally speaking, the presumption is if money was earned, it's community. Often what happens is one of the spouses, one of the spouses of the divorce will say, hey, we had this conversation where we said, yeah, what's mine is mine, what's yours is yours. That's not going to cut it. You need something in writing signed by both parties. I say parties, but spouses, which is because usually spouses don't sign those kinds of things, right? A couple people last class mentioned that, one spouse put the other through law school. I'm pretty sure that there was no written agreement to that effect, right? Or anything else. So these kinds of things do not get held up in court. Okay? The exception to this is inheritance. Okay? If while you're married, you inherit property, meaning the wife inherits some land from her father who died, that's considered separate. That's not considered marital. Okay? Same for a gift, right? If someone gives a gift to one of the spouses of land, right? I give you Blackacre and I'm only giving it to you, that's considered separate. Also, if the wife owned any property individually beforehand, that doesn't become community property. It remains individually owned. Right? So one of the ways, and you can just, I think this was on the exam last spring, I can't remember when it was, where a couple got married, they had some property before, they got some property during the marriage, then they inherited some stuff, and you have to walk through and try and figure out which is actually community and which is not community. Okay? Again, parties can contract around this with a prenuptial amendment, right? If you enter into a prenup, right, you can say, my money that I earn is mine, yours is not. Courts may not hold that up if it totally screws over one of the spouses. So even then, even if you come to this arrangement in advance, when it comes to a divorce, the other spouse might not be so happy about it and will challenge it. So these are often litigated very heavily. Okay, any questions so far?
So the couple is, let's say, a week from getting married, and they purchase a home, and the husband purchases it in his name.
Right. Do they make it like a joint tenancy or anything, or no?
He has to be simple title.
So he hasn't. He's not. It's no co-ownership.
Correct, because they're engaged. Or, I mean, and he's not very nice. My question is that, let's say they live in that home as their marital home for 10 years. Does the wife have any claim or stake to that property?
Okay. So let me restate the example. So the example's like this, right? A week before the marriage, the husband buys a house. He does entitle to joint tenancy, right?
Correct.
And then they live in it for 10 years. Does the wife have any ownership claim to it? No, unless she has an adverse possession claim, but I don't think it's hostile, unless it's a really hostile marriage.
What if they refinance it during the course of the 10 years?
Well, okay, so that's a different example. You said he bought it in full, right? We'll do an example later if it's talking about repaying stuff. That's a different deal. But the example was he bought it in full. He owned it.
If he bought it with a mortgage and then subsequently refinanced.
That depends. We'll talk about that like in 20 minutes. That's actually an open, depending what state you're in. But we'll talk about that. Other questions? Right? Okay. So there's a couple interesting wrinkles with Texas in particular. What happens if the example she gave before, the husband owned a piece of property before the marriage and then he rented it? What about the income from that rent? And actually, the Texas law says in Texas, any rental income is now community property. So even if the husband owned a piece of land before and it's renting it during the marriage, whatever rental money comes in is now community. So she has half, right? Or he has half, as it were. Most other community property states do not have that. The income property is considered separate. All right. Now, this kind of, yeah.
Would income earned before the marriage, would that be community?
Income
Separate?
earned beforehand would be separate.
So
Okay.
any income on the rental property after?
Yes. Right. But what's interesting is you also have to look out for commingling, right? So even if, say, I'll use the example you gave, he owned a house, right, before the wedding, and then after the wedding, they decided to renovate the house, and he only did it with his own money, right? But because he's now married and using money to renovate the house, it's very possible that there might be some kind of commingling going on to give the wife a share in the home. So refinancing is not a perfect example, but various things to mix money around. Maybe he paid the rent with their joint account, may actually transform it into community property. So you have to be very careful. I think the lesson should be learned is if you're living in California or Texas, whatever, it's very hard to be married and not have community property. Like you can make mistakes or whatever, and your property suddenly is transferred.
What happens if like you're in the process of a divorce and then you purchase like property?
That's not a very good idea.
Yeah,
You should probably wait till after. Well, actually, what often happens is that right before a divorce, right, people will sell all their assets. That way they can't be divided up. And then magically, the person they sold to will give it back to them after the divorce is finalized. This happens a lot. So basically, people they try and dump their assets. So that way less gets divided up in the divorce. And then magically, right after the divorce, they reacquire the assets. And in fact, courts can actually set aside those conveyances, right? If a court finds that someone dumped a piece of property for like a very low price, right before divorce was to be finalized, they can actually set aside that conveyance. Because it means it's basically fraudulent conveyance. We did a case like that with the couple in Hawaii.
Alternatively, could they set aside attempted return conveyance?
Well, actually, they would force the return. They wouldn't even get to return because as if they never transferred in the first place. So there would be no need for a return because as if the transfer in the first place never happened.
Well, yeah, no, that's what I'm saying.
Yeah,
the conveyance go through, but then when the person tried to give it back, they were like,
No. The reason why is because they would need to include it within the total assets as the divorce.
I heard that if a husband buys land with his separate money and a wife builds a house on that land with her separate money, that it now becomes his separate property because the house affixes to the land.
Oh, I don't know.
No, okay.
I'm not sure. I mean, I think at that point, there's a lot of commingling going on. And in the event of a divorce, a judge would probably find that that's community property. In other words, the presumption is it is community property unless a husband or wife has very strong evidence to the contrary. And like if it's a maybe, like it's kind of a murky issue, in Texas, the default is community, right? That's like the default rule. And you have to have serious evidence to prove that's not. You have to take serious steps to avoid that from happening, right? You can't even get around it. Are other questions on that? All right. The book also gives the example of dividends from stock. So say the husband owns some stocks from before the marriage, but the stock pays dividends. If you know what that is, if you own certain stocks, they actually pay you some annual amount of money to hold the stocks. In most states, the dividends would be separate, but in Texas, those are actually considered community. So much like the rental property, money you get from prior investments during the marriage remains as community property, and that gets added to the entire pool. The book also talks about creditors. So generally speaking, the creditor must go after a spouse's separate property first before they go after the community property. Although as a practical matter, most people in Texas and elsewhere don't have much separate property. Everything's basic community. So creditors can, after they exhaust the separate, go after the community.
Can husband and wife, they agree by written agreement and say they change the character of the property?
Yes.
They said it's
Yes. So this is what's called transmute, which is kind of like transubstantiation of both property, right? You basically change the characterization of the property. So the husband and wife agree, okay, you know what? Blackacre between they can. Now, where this becomes really important is say you have a couple moving from New York to Texas, right? Well, one of the things they probably should do is transmute their property to community. That way the wife is protected in the event the husband tries to disinherit her. You see? Right? Or if you're moving from Texas to New York, you might want to transmit your property as well. Now, let me make one point clear. When a couple moves from New York to Texas, their land doesn't move. I know that sounds really obvious, but people actually get confused about this. Your land stays in New York, right? But the ownership is characterized by how you bought it. So if you're living in New York and you buy Blackacre in New York, you can actually, by written agreement, say we want this to be community, and New York will respect that. Same way, if you come to Texas and you buy Whiteacre in Texas and you say we want this to be separate, and you have this signed agreement, Texas will respect that. So the husband and wife can always, by written agreement, transform it. But until they do that, it remains the same, right? They give the example, the wife buys a horse in Texas, the wife buys a horse in New York, and they bring the horse to Texas. That horse remains separate property, okay? Now they buy this and they bring it to New York. The horse remains community. The piece of property, whatever it is, retains the characterization from when it was acquired. And it doesn't change until the parties have written agreement.
Residence, tenure of residence in the new state doesn't
Change anything.
matter. Okay.
And this is a lot of people get tripped up on the exam. To think, oh, wow, they moved. That means the property is, no. The property, whether it's real property or personal property, a horse or a piece of land, doesn't matter. It stays the same. I'm almost positive I haven't written it yet, but if I give you a community property state, it'll be Texas. I mean, which is why I don't ask about California. California, I mean, it's funny. In California, they take a specific class in California community property if you go to law school there, and that's a really hard topic on the bar. I don't even know all the rules. I'll stick with Texas.
If the couple's living in Texas and they buy a home in a common state, it's based on where they're living, not where the couple is located.
Yeah, so yeah, you're right. So this is what makes it a little bit tricky, right? So a couple lives in Houston and they buy a piece of land in New York, right? It's based on the domicile of the couple. So because the couple is domiciled in Texas, that land in New York will be deemed community property. That's exactly right. It's almost counterintuitive. So the characterization of property is based on the domicile of the parties at the time of the transaction, right? And to give the flip of what you just said, right? Couples living in New York, married couples living in New York, and they buy a home in Austin, right? That will now be characterized as not community property. It's based on the domicile of the parties. That's right. Everyone get that?
So, the status of the property.
The status of the property is based on the domicile of the parties when they buy it.
It's not based on the location.
No, that's why New York will respect something as community, right? But again, during the lifetime of the couple or during the marriage of the couple, it doesn't make a difference. It only matters at death or divorce, right? So another aspect of this is what happens when you die or get divorced, right? Well, usually, if anyone knows about this, probate is what happens when you die. It happens in the place where your body turns cold. Generally speaking, it's where you die. But often it's contested. Happens if, I live in Houston and then tragically I get into a car accident in New York on a vacation, I die there. Is my will probated then in Houston or in New York? And this is actually a severely issue. Usually it's with a domicile. They actually die. Hopefully same thing, but it happens. Ditto for divorce, right? What happens if a couple gets married in New York and they move to get divorced, right? The divorce law of Texas for their New York property, which makes it separate. It gets really tricky when you start moving around between states. And generally speaking, probate is done where you live and die, which may not be the same thing. And divorce is based on where you live. There's actually an interesting case. We've discussed same-sex marriage a couple times before the Texas Supreme Court that's been pending now for almost 2 years. So the issue is like this. 2 women were married in, I think, Massachusetts, and they came to Texas and they wanted a divorce. And the reason why they wanted a divorce is to separate assets and get a custody arrangement for the kids and whatever else, right? Under this law, they said, well, under Texas law, they not have recognized the marriage, therefore they can't grant the divorce. But a judge, I think it was in Dallas, basically said, yeah, whatever, I'll give you the divorce anyway. And the attorney general freaked out and had an emergency intervention. But if you think about it, if a couple can't get divorced in the place where they live, they can't get divorced anywhere. Marriages can be performed anywhere. Go to Las Vegas, Elvis, right? But a divorce has to be performed in the place the couple's domiciled, or at least one of them is domiciled, if for whatever reason. So it gets actually very tricky. So let's maybe we can walk through. All right. So generally speaking, when you acquire property, you characterize it based on the residence of the couple. Right. So if they buy a piece of property, if they live in Houston, they buy a piece of property in New York, it'll be characterized as community. If they live in New York and buy a piece of property in Houston, it'll be characterized as common law. Okay. So that's the short rule, but there are all these other interesting aspects to it. All right. Any questions on that? Yeah.
Which states do you need to know for the condo?
I think I told you. I mean, there's like 8 community property states, but I'll ask you about Texas. I'm not gonna punish you unduly for that. I'll ask the one that might actually be salient to your lives. Yeah, but it's like what? It's Texas, California, Idaho, Louisiana, Washington, Alaska, Wisconsin. I don't remember the. Oh, here it is: Arizona, California, Idaho, Louisiana, New Mexico, Texas, Washington, and Wisconsin, Alaska. So basically 10 states. If you ever go on Jeopardy, you might need to know that, but for our purposes, just know about Texas. All right. All right. So what is then the benefit of community property? Well, it kicks in at death or divorce. The presumption is, since while you were married, the husband and wife owned 50-50, when the husband dies, 50% goes to the wife. But more precisely, 50% of the husband's share goes to the wife. So say, for example, the husband and wife own a piece of property as joint tenants. Wife owns half, husband owns half, more or less. When the husband dies, the wife gets the husband's 50%. This is not survivorship, right? This is not like the right of survivorship. The wife actually gets the husband's interest that transfers over. Same way, say that the couple has a bank account that's worth, $100,000, right? The wife own half, husband own half. So they each own $50,000 each, right? When the husband dies, right? What's half of the husband's share, which is $25,000. So this is where it actually gets a little tricky, right? So say you have a joint bank account of $100,000, right? Husband has 50, and the wife has 50. Under community properties, presume that any joint bank accounts own 50-50, right? Husband dies, disinherits the wife, right? Doesn't matter. Can't get around that. The wife gets half of the husband's property, which is 5. I know everyone wants to say, oh, the wife gets half, so she gets 50. But we have to be very precise. The wife gets half of the husband's interest. Half of the husband's interest is 25. See, trips people up. The entire bank account's $100,000, right? It's presumed the husband has 50,000, the wife gets 50,000. When the husband dies, the wife keeps her share. Nothing goes to that. But what actually transfers is half of the husband's interest. Half what, and half what the husband has is 25,000. So the wife now gets $25,000. No. Same. Yeah. Of half of their share, right? Let's do this a problem. The one with the insurance policy, right? It's on page, hold on, what page is it on? It's the father and the son, the insurance policy. Here it is. Let's look at this problem. Okay. Okay. Yeah, that's it. Problem number 1, okay? Let's walk through this one. I think this illustrates how this gets a little complicated. Okay? So it says during husband takes out a 50 insurance policy. Yeah. So during marriage, the husband takes out a $50,000 life insurance policy on his life, paying premiums out of his earnings. Okay? So this is, again, it's in a community property state. For this $50,000 life insurance policy, right, out of community property, money being earned for his paycheck is paying for this policy. Therefore, this insurance policy is community property. Everyone see that? And with community property, okay, the husband doesn't own all of it. Even though he designates his son as the beneficiary, right? In other words, he takes his wife out of all of it. He designates his son for all of it. The question is, can he do this, right? Can he take his son and give him all the money? Under property law, the answer to that question is no. Right? All that he can dispose of, half, right? He can only dispose of his half. So of this $25,000, right, half goes to the wife. I'm sorry, of the $50,000, half goes to the wife, and the son is entitled to 25. See, this is what's, let me walk through some more time, right? Because this $50,000 insurance policy was paid for by community funds, presumed that any proceeds from it will be split 50-50. The husband has a $25,000 share, and the wife has a $25,000 share. Even though it's not so designated, as a matter of law, that's how it's perceived. Therefore, the husband can only dispose of half of the entirety, which is his share of $25,000. So the husband can give $25,000 to the son, and the wife takes $25,000 regardless. So it's absolutely true that the husband can dispose of half of the estate, but that is his interest. His interest is only half because the other half is for the wife. Everyone see that? This is probably one of the trickier problems in the entire topic, which I like to do it first. They bury it at the bottom.
So the way you explain that makes sense, but the previous example, he was only able to get rid of half and
I don't remember what example I gave.
Well, it was 100,000.
Okay, so I forgot. Okay, so if it was a $100,000 property, right? It's presumed that actually, okay, I think I mixed up the numbers. Okay, it was a $100,000 property, right? Then effectively during the marriage, the wife owns 50, the husband owns 50, right? The husband can only dispose of his $50,000. Okay, I think I mixed the numbers in my head. I'm sorry. Okay, so everyone sees that. Even though the husband gave all of it to his son, as a matter of law, he can't do that. He can only dispose of half, which is his share, which is $25,000 of the policy. You're right. I think I mixed up the numbers, so I apologize for that.
The 25K just doesn't apply. So she gets.
As a matter of law,
50K, of the 100K, she gets 50K, and then what happens?
he can dispose of half, his half, to whomever he wants. So using this example, right? The husband designated his son to get everything, right? Look at this example. The named beneficiary, right? The son gets everything. And since the named beneficiary is a son, according to the father's wishes, the son gets everything. But they can't do that as a matter of law because the husband can only dispose of half of it.
Yeah, but for the word prior, I just want to make sure.
I think I said it wrong.
Okay, well, if
Yeah.
you did, can you clarify what you did want to say?
The husband disposes of his half, right? So if it's a $100,000 estate, right, and which presume the wife has 50, the husband has 50, then the husband can dispose of 50.
So the husband can dispose of his entire fee.
Of his 50, yes. All right, one at a time. All right, everyone see that? We'll do the second part of it later about the premiums, right? But everyone see that much. You can only dispose of what you have. And on a community property, you only have half. So the husband can only dispose of half to the son.
I would have, it was paid for with community funds. It wasn't community property.
It is.
But it was his property.
Even though he pretended it was, as a matter of law, it's community. See, he pretended this was like his own, but as a matter of law, he can't. In fact, in all likelihood, if he had actually tried buying this policy in Texas and he said he was married, I don't think they would have even written this policy out with having the son as a beneficiary, because you understand if the person's married, the spouse takes part of it, right? I mean, you can write this policy, maybe bought in another state, who knows, right? But you can write this policy out, but it won't be valid because they'll take half as a matter of law. I think I know what happened. When I said 25, I was thinking of this one. Oh, okay. That's what happened. Okay, everyone see, yeah, no, I gave the example of 100, but this one was in my head and I thought of 25, and that's why I quartered it. Okay, I apologize for that. Okay. Everyone see that? Everyone get that problem? I apologize if I it's been a long day. All right, any questions on that? All right. Okay. Right. So generally speaking, everything's half. Whatever earnings are half, whatever stock dividends are half, anything acquired is halved. And when there's a divorce or a death, and the husband tries to give the wife nothing, or the husband disinherits the wife, courts will step in and force that half to go to the wife to dispose to her. Right? All right. All right. Let's talk about concurrent estates. So I think when we discussed the tenancy by the entirety, I said that these really don't exist in community property states. They may have it, but it's not really necessary, right? Because the idea of the tenancy by the entirety is to have them owning it. Is it a hand? Is to have it as a joint undivided whole, right? But when people own stuff in community property, that's how it's treated. They each have basically the entire thing owned together. So for the most part, in Texas or elsewhere, if your couple's married, they'll title it as a joint tenancy if they so choose. But much like a tenancy by the entirety, with a joint tenancy, one party cannot convey the entirety of the property, right? With the usual joint tenancy, and you're not married, one party can convey his interest, and that severs a joint tenancy, makes a tenancy in common. Okay? With community property, when you have a married couple, one party cannot convey the entirety of the estate. Why? Because that spouse only owns a half share, right? There is no separate shares involved. So one spouse can't legally convey the entirety of the property. All right. Okay. And again, there's no need for survivorship because say a husband and wife own it in joint tenancy, right? The wife already owns half. When the husband dies, she gets his half, and now the wife owns 100%. Everyone see that? So you don't need a right of survivorship for married couples. All right. Questions on that one? All right, let's try one of the problem which I want to do first. I think I jumped ahead too soon. It's on home. There's it. All right, so it says, what did I finish last time? Okay, right back there. All right, so Harris, you want to read the problem right there?
Yeah, H married to W saves $5,000 out of his earnings, which he involves in savings account in his name, and subsequently he withdraws falls that money buys a lot, taking title, and with H and W as joint tenants, he then dies and, or he had tried to give all his property to his son, who owns the lot. I feel like in this case, if they are joint tenants, wouldn't that mean that he can only give 25% of his share to his son?
Right. Good.
So
This was the question I was thinking about with the 25. I had split in my brain. That's right.
So the wife gets 75%.
Okay, good. All right. So what happens here, right? So the husband is married to the wife, okay, and they say $5,000 out of his earnings, which he deposits in a bank account in his name only, right? Harrison, does that matter that it's in his name? Does that make any difference in Texas?
I don't think it makes any difference.
It makes no difference. It's presumed to be community. It doesn't really even hide, okay? So effectively, he's using this $5,000, right, which is now community property. So he buys a piece of property, and he titles it with the husband and wife as joint tenants, right? He writes a will devising all of his property to his son, okay? And Harrison, to finish it up, what exactly is the husband? I'm sorry, what's that?
It's Jesse.
Oh, Jesse, I'm sorry, you're one seat over. That's fine. Jesse, what is husband's interest during this marriage as joint tenancy? Of this piece of lot, what's his interest?
This community property.
Good. And what percentage of it does he own?
50%.
Half, right? The husband has 50%, the wife, right? So what is the husband allowed to give in his will to someone else?
50%.
50% of what?
Of his.
Yes. Okay, that's right. I jumped the gun, so I apologize for that. The husband can dispose of half of his interest. He owns 50% of the land. The wife has her half. The husband has 50%. He can only leave a quarter, 25% to the son. The husband can leave his interest. So half of a half is a quarter, right? Half of 50% is 25%. Why?
Completely opposite of what you just said. You said he can leave his entire half.
He can leave half of his interest, right? Case, the wife already owned half. The husband has his half, so he can leave half of his interest away.
Why only half? Because he owns 50%.
How is it different than 50,000?
Yeah.
1 second. I think I may be. 1 second.
Is it matter that it's labeled as a joint tenancy?
The
Okay.
I think no. I think this is. Just give me a second, okay? No, I think this is right.
I think you're right.
I think this is right. Effectively the even when you own community property, right? If you are a person in community property, your entire share doesn't necessarily go to the wife. The only thing that goes to the wife is half of your share. And half of his share, so the wife gets the 50% half.
So whenever one spouse dies, the other spouse gets 75% automatically?
Well, it's not 75%. In this case, she already owned 50%. Before, the wife didn't have any of it to begin with. You see, this is a joint tenancy, right? This is a joint tenancy which already presumed the husband owns half and the wife owns half. And even when you have joint property, you can dispose of half of your estate to whomever you want. The other half goes to the wife. And that's right.
Because it's joint.
Right. The example I gave before was a life insurance policy where apparently the wife had none of it. Right? The example I gave before, the husband tried to cut the wife out of the picture altogether. right? And only became known when he was actually dead. This example, he titled it as joint tenancy. So he gave half to his wife and he had half. So he can still dispose of his half to the wife.
Would that be effective in that exact same scenario in Texas? Could he do that, or?
This, yes, this would be an example in Texas. Right?
I was thinking that in Texas, automatically it's community property, and so.
Oh, you're talking about the life insurance policy?
No, sir, even this exact $5,000 situation that
Right.
we're talking about, that in Texas, community-wise.
It would be. So really, he didn't need to title as joint tenancy, right? But the fact that he did gave the wife up front 50% because effectively,
Of his 50.
well, it was 50-50. And then when the husband dies, he can dispose of 50% of his 50%, which is 25%. The husband could dispose of half of his half. He can only keep half of his half.
In a joint.
Yes.
What do you consider as community property though? As in the wife's share, is it considered as community property?
The property is titled as community, but under the joint tenancy, it's 50-50.
Even if it's still considered as community property?
Yes. That's how it's viewed in terms of here.
Would you mind just going to your work page and just walking through a trial?
Okay. Yeah.
Kind of visualize.
Right. I mean, this is effectively the same. I mean, it basically that 105,000. So you have $5,000, right? Which is, well, actually, we're not talking about money. We're talking about percentage of an ownership of a piece of land, right? So the land purchase, right? Right? He can give away half of his share, which is exactly the same there, right? The husband, this was 25. The husband gave away half of his share.